Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. Today's episode covers search and seizure and comes to us from FLS Family's channel. Be sure to check out the description below and give them the credit that they deserve. Let's dive right in and audit the audit. This video, published on July 14th, 2019, shows two officers from the Billings Police Department in Billings, Montana, making contact with a Mr. Frank in an attempt to gain consent to search a vehicle registered in his name.
How you doing, sir?
How's it going, man?
Frank, right?
Yes, sir.
Oh, hey, nice to meet you, man. Hey, so I don't know if these ladies explained to you what's going on.
Yeah.
But basically, there was a shooting.
Okay.
And one of the suspect vehicles that was listed as like leaving the area, possibly a black Dodge Nitro.
Okay.
Hence why we're here, right? And
With rims or just black Dodge Nitro?
Yeah,
chrome rims.
Yeah,
Okay.
like no shit with rims too.
Okay.
So there happened to be a bike officer who was driving by and seen, obviously these two leaving the area, and that basically that's where we're at. We've already spoken with everyone out of this residence and them, and I think everything is, everything. We have no reason right now to expect or believe that they were involved, right? But with your permission, at least, the vehicle's registered to you.
Yeah.
Just to cross our T's and dot the I's and just make sure everything's safe. We're going to ask you if maybe we can ask for consent just to search the Jeep.
No.
No, not going to happen.
No.
Okay.
The Fourth Amendment guarantees the right to be free from unreasonable searches and seizures, and citizens retain the right to refuse consent. And that's what Mr. Frank does here. However, there are certain circumstances which grant officers the right to conduct a search without first obtaining a warrant. An officer may seize evidence without a warrant if an officer is on the premises lawfully and the evidence is found in plain view. While conducting a lawful arrest, an officer may search an individual's person and their immediate surroundings for weapons or other items that may harm the officer. If a person is arrested in or near a vehicle, the officer has the right to search the passenger compartment of that vehicle. Police are not required to obtain a search warrant if they reasonably believe that evidence may be destroyed or others may be placed in danger in the time it would take to secure the warrant. An officer may search a vehicle if they have a reasonable belief that contraband is contained inside the vehicle. Police may enter a private dwelling if they are in hot pursuit of a fleeing criminal. Once inside a dwelling, police may search the entire area without first obtaining a search warrant. Luckily for Mr. Frank, these officers did not choose to invoke any of the exceptions listed here.
Because it
You got a warrant,
If
that's
she's
fine.
cleared out, then why? If she's cleared out, then why do you need to search the vehicle?
We just have to, just to be sure.
Yeah. Just
You already ruled out the.
Yeah.
That doesn't make sense to me.
No, it's just not going to happen, so
95%.
no big deal.
We're
It's
not
just,
100% sure.
No big deal.
That would just help us to get there.
yeah, well, I'm
And
for sure,
if
so.
you're, we're just trying to clear everyone here, right?
Is she
like
cleared
you
or is she not cleared?
We're like 90% sure, right?
Okay.
That extra 10% would help us out a lot.
Well, I don't believe in that kind of stuff, so. I know what my kid has done and that. So if I would have had anything, I'd have said, hell yeah. You know what I mean? Because
Today, she left today to come over here to get baby clothes.
But yeah, I know for a fact that there's no weapons, there's no nothing in that vehicle, so there's no need to search it. That's what it is. If you guys want to take it further there, it's fine too. But
yeah, that's your if that's your prerogative and that's how you want to do it, that's fine.
Yeah,
but for right now,
because I know what's what. You know what I mean?
Right. You.
And I think you do too.
You do for your daughter.
You want to take it a little further, and you know what I'm saying.
We just want to be sure. We just have to make sure.
Well, what rolled her out for you guys?
What's
You
that?
said she was rolled out. So what rolled her out?
Her story.
Basically,
what she said she did, and that
just
cleared
this
it.
whole thing's an evolving investigation, right?
Yeah.
Like he had said, we're at like 90%. We just like that little push of assurance at the end to make sure everything's clear.
Yeah, no, that's fine.
And I know as a father, correct?
Yep.
I'd be, the thing is, you don't know exactly where she's been.
Law enforcement officers are under no obligation to be truthful when interacting with members of the public. The 1969 Supreme Court case of Frazier v. Cupp affirmed the legality of deceptive interrogation tactics and essentially granted officers the ability to lie in the line of duty. The officers stating that they are 90% sure that Mr. Frank's daughters were not involved in the shooting could be a deceptive statement meant to establish a positive repertoire with Mr. Frank in an effort to gain consent to search the vehicle. It is also possible that the officers genuinely do not suspect the daughters of being involved in the shooting, but do suspect that the vehicle was involved. It is impossible to know the true intent behind the officers' statements here, but the statements and intent which is presented to a judge in the form of an affidavit often contains vastly different and subliminal information which remains unknown to the interacting parties involved at the scene.
Well, I know she was here. She wasn't. She lives with her mom, so she was with her mom. Then she came here, and then she went to Sonic. I know exactly where she was at.
Okay.
I left her house, went to my ex-boyfriend's to drop off his shirt, stayed there for like 5 minutes.
I know.
Left,
Okay.
came here, sat
Fair
here.
So yeah, there's no. I wouldn't. No.
Okay.
I wouldn't worry about it.
Well, I mean, it's our job to worry about it, right?
Well-
Because there was a huge event, and we have to investigate to our fullest. Otherwise, our ass is on the line. And I'm sure you understand.
Oh
that too.
yeah, I get you.
So for right now, then I guess the Jeep's not going anywhere.
The Jeep's
Just
not going nowhere.
Yep, just for right now, it's
So
not going anywhere.
is she detained?
Is that even a Jeep?
No.
Okay,
No,
then we
she's
can
not.
go anywhere we
No,
want.
But right now,
What do you mean?
no.
I can get in my car and I can leave with my car.
Well,
Am I detained?
You just told us to get a warrant.
The automobile search exception listed earlier in this video was established by the 1925 Supreme Court case of Carroll v. United States and is based on the idea that there is a lower expectation of privacy in motor vehicles due to the regulations under which they operate. The ease of mobility creates an inherent exigency to prevent the removal of evidence and contraband. In the 1996 case of Pennsylvania v. LeBron, the Supreme Court stated, if a car is readily mobile and probable cause exists to believe it contains contraband, the Fourth Amendment permits the police to search the vehicle without more. It could be argued that these officers already had the probable cause and circumstances necessary to conduct a warrantless search of the vehicle, and some courts would probably accept the use of the automobile exception in this instance. However, the officers failed to invoke the automobile exception and elected to attempt to acquire a search warrant instead.
Yeah, get a warrant. Yeah.
So that's
So-
the route we're
So you're gonna take time to get a warrant?
Get a warrant.
yeah.
Okay, you better have some pretty good proof that this is the vehicle if you want to get a warrant.
We don't make that decision.
Because
a
it's
judge-
called proof
a
to get
judge-
a warrant,
judge-
not just a hearsay.
Probable cause, actually.
Hearsay. So
Well, then let them get a warrant. They
So-
can
Get a
search
warrant,
it,
yeah.
they
We'll
get a warrant.
present the probable cause to the judge. The judge will either grant the warrant or deny the warrant.
Okay.
And then we'll go from there.
Yep.
problem.
But in the meantime, it has to stay where it's at.
Why can't you just let them search it?
because it's
so
bullshit.
stupid.
It's bullshit.
Yeah,
Hey,
I know.
we're kind of past that point
You
now.
know.
So.
Yeah, we are past that point.
All right, I'm gonna.
Good luck on that. So what if I take my car? What are you gonna do? You're not gonna let me in my car?
No, you're not. Dad,
Give me my
seriously,
keys.
dude,
Give me my
stop.
keys.
Dude.
Give me my keys.
Frank, don't. Just let them get a warrant.
No one is getting into the car.
What are you gonna do?
It's being seized.
What are you
I'm
gonna
gonna
do?
Put you in handcuffs for
You're gonna physically assault me for touching my vehicle.
I'm gonna detain
Dad,
you
quit.
for
Please
interfering
stop.
with the investigation.
Is this
In the 2001 case of Illinois v. MacArthur, the Supreme Court ruled in favor of police officers preventing a man from entering his home while they obtained a search warrant because the officers had probable cause to believe that the man had hidden marijuana inside his home. This ruling essentially reaffirmed the precedent that officers may seize certain property to prevent the destruction of evidence if the officers believe that they have the probable cause necessary to obtain a search warrant. Whether or not the probable cause acquired by the police officers actually validate a search warrant is at the discretion of a neutral judge. Most courts would likely agree that the officers were within their authority to prevent Mr. Frank from entering his vehicle in order to preserve any evidence that may be inside.
car?
It's fine. I'll drive.
It's a black Dodge Nitro
Okay.
with big chrome rims.
And who's
It's
this person
exactly
saying
what we got. Witnesses to the crime.
And you got names?
Those are not names that we're going to put out.
Just go.
Just
If they're-
do their job. Let them.
I
do
have the
whatever
right
they
to
do.
confront my person, right?
What?
I got the right to confront the person saying something about somebody on me, right?
No one's saying anything on you.
The car is mine.
Okay.
So what are you saying? They're not saying something about me? It's me. It's my car.
You're not one with the car.
So get your warrant.
Okay, we're going to.
Try to.
Okay.
Oh my god. Well, just let them do whatever.
Have fun with that.
Wait. Let's just leave him.
I got this all recorded, so. Because you don't wear body cams, right? No accountability? Oh, right on.
Let's go. God.
And you pull guns up in here? You had guns pulled in here? Yeah.
Guns that they had. I had kids came swimming here. Like,
Show any kind of proof that my car was there. Any kind of proof.
Let him be. Just let them be.
That.
No. Do you rather get shot? No.
According to the description of the original video, the officers eventually left the scene without obtaining a warrant or searching the vehicle. It is unclear whether the officers involved were denied a search warrant or if they ever even attempted to acquire one. Either way, the officers left empty-handed and Mr. Frank was not arrested. Overall, the officers from the Billings Police Department get a C because they respected the rights protected by the Fourth Amendment and attempted to work within their authority to dispel the suspicions surrounding the vehicle in question, but ultimately abandoned their efforts to search the vehicle, rendering their interaction with Mr. Frank as nothing more than an inconvenience. No real police work was done during this interaction, and no streets are safer because of the actions of the Billings Police Department. If the officers were so sure that Mr. Frank's vehicle had been involved in a shooting, then surely they would have been more vigilant about searching the vehicle. But the fact that the officers left the scene empty-handed implies that their suspicions were not valid enough to warrant a search, and the officers were simply fishing for consent. Mr. Frank gets an A- because he stood his ground, invoked his constitutionally protected rights, and rightfully questioned the legality of the officers' conduct. But Mr. Frank allowed his ego to cloud his judgment and came dangerously close to being unnecessarily arrested. It is important to find a healthy balance between defending your rights during your interaction with the police and defending your rights later in the courtroom. Ultimately, Mr. Frank defended his property from what appeared to be an unreasonable search and was able to avoid further incident. Let us know if there's an interaction or legal topic you would like us to cover in the comments below. Thank you for watching, and don't forget to like and subscribe for more police interaction content.